Question 1. Benchmark analysis indicates that when creating property listings in Victoria, agents must navigate a complex landscape of consumer expectations and regulatory requirements. Considering the principles of fair trading and accurate representation, which of the following approaches to describing a property for sale in Victoria is most aligned with professional and legal obligations? Option A. A description that focuses on verifiable facts about the property, such as its dimensions, number of rooms, key features, and proximity to essential services, while avoiding subjective superlatives. Option B. A description that uses evocative and aspirational language to create an emotional connection with potential buyers, emphasizing the lifestyle the property could offer. Option C. A description that includes personal opinions and endorsements from previous residents to convey the property's desirability and unique appeal. Option D. A description that highlights only the most positive aspects of the property, using strong adjectives and omitting any mention of potential challenges or areas needing improvement. The correct answer is A. A description that focuses on verifiable facts about the property, such as its dimensions, number of rooms, key features, and proximity to essential services, while avoiding subjective superlatives. Explanation. Scenario analysis. This scenario presents a professional challenge for a Victorian real estate agent tasked with creating a property listing. The core difficulty lies in balancing the need to attract potential buyers with the legal and ethical obligation to provide accurate and non-misleading information. Failure to do so can result in significant penalties under Victorian consumer law and professional disciplinary action. The agent must exercise careful judgment to ensure the description is both appealing and truthful, avoiding any statements that could be construed as deceptive or that exaggerate the property's features or benefits. Correct approach analysis. The best professional practice involves crafting a description that is factual, specific, and highlights the property's genuine advantages without resorting to hyperbole or unsubstantiated claims. This approach aligns with the principles of honesty and transparency mandated by the Estate Agents Act 1980 VIC and the Australian Consumer Law Act. A truthful description, focusing on verifiable attributes like the number of bedrooms, land size, proximity to amenities, and recent renovations, builds trust with potential buyers and reduces the risk of misrepresentation. It allows buyers to make informed decisions based on accurate information, thereby fulfilling the agent's duty of care and professional integrity. Incorrect approaches analysis. Using vague and aspirational language such as a dream home waiting for its new owner or unbeatable lifestyle opportunity without providing concrete details is ethically problematic. Intended to create appeal, such phrasing can be subjective and may not accurately reflect the property's reality, potentially misleading buyers. Including subjective opinions presented as facts, like "this is the best location in the suburb," is a direct contravention of the requirement for factual accuracy. Such statements are not objectively verifiable and can lead to disputes and claims of misrepresentation. Omitting crucial negative aspects or potential drawbacks, such as significant ongoing maintenance issues or proximity to undesirable features, constitutes a failure to disclose material facts. This lack of transparency is a serious ethical breach and a violation of consumer protection laws, as it prevents buyers from making a fully informed decision. Professional reasoning. Professionals should adopt a systematic approach to property description. This involves 1. Fact gathering, thoroughly understanding the property's physical attributes, legal status, and any relevant disclosures. 2. Objective description, detailing features in a clear, concise, and verifiable manner. 3. Highlighting genuine benefits, connecting factual attributes to tangible advantages for a buyer, e.g., large backyard ideal for families rather than just large backyard. 4. Review and verification, ensuring all statements are accurate and can be substantiated. 5. Compliance check, confirming adherence to the Estate Agents Act 1980 VIC and the Australian Consumer Law. Question 2. The evaluation methodology shows a first home buyer in Victoria, Australia, expressing interest in government-backed loan schemes to assist with their property purchase. What is the most appropriate initial step for the real estate agent to take in response to this inquiry? Option A. Recommend a specific government-backed loan product that the agent believes might be suitable for the buyer based on their stated income and savings. Option B. Provide general information about common government-backed loan schemes available in Victoria, explain their typical purpose and broad eligibility criteria, and strongly advise the buyer to consult with a qualified mortgage broker or financial institution for personalized advice and to confirm their specific eligibility. Option C. Advise the buyer that government-backed loans are complex and that they should only pursue traditional home loans without exploring these options further. Option D. Offer to assist the buyer directly with their loan application process for a government-backed scheme, assuring them that the agent has experience with these types of loans. Correct answer is B. Provide general information about common government-backed loan schemes available in Victoria, explain their typical purpose and broad eligibility criteria, and strongly advise the buyer to consult with a qualified mortgage broker or financial institution for personalized advice and to confirm their specific eligibility. Explanation. The evaluation methodology shows a scenario where a real estate agent in Victoria, Australia, is assisting a first home buyer who is exploring government-backed loan options. This situation is professionally challenging because while government-backed loans can be beneficial, they come with specific eligibility criteria and obligations that both the buyer and the agent must understand. Misinterpreting these requirements or providing incomplete information can lead to significant financial and legal repercussions for the buyer and professional misconduct for the agent. Careful judgment is required to ensure the buyer is fully informed and that all actions align with Victorian consumer protection laws and the specific guidelines of any government loan schemes. The best professional approach involves the agent proactively identifying and explaining the relevant government-backed loan schemes available in Victoria that might suit the buyer's circumstances. This includes clearly outlining the general eligibility criteria, the types of properties typically covered, and the potential benefits and limitations of each scheme. The agent should then advise the buyer to seek independent financial advice from a qualified mortgage broker or financial institution to confirm their eligibility and understand the specific terms and conditions of any loan they might be approved for. This approach is correct because it prioritizes the buyer's informed decision-making by providing foundational knowledge while directing them to the appropriate professionals for detailed assessment and application. It aligns with the ethical duty of care and the requirement under Victorian law to act in the best interests of the client, ensuring they are not misled and have access to accurate information to make sound financial choices. An incorrect approach would be for the agent to assume they can provide definitive advice on loan eligibility or to recommend a specific loan product without the buyer consulting a financial professional. This is a regulatory failure because real estate agents are not licensed financial advisors and are not qualified to assess loan eligibility or provide specific financial product recommendations. Doing so could constitute misleading or deceptive conduct under Australian consumer law, potentially exposing the agent to penalties and reputational damage. Another incorrect approach would be for the agent to only mention the existence of government-backed loans without providing any context or explanation of their general nature or eligibility. This fails to meet the professional obligation to provide adequate information and support to the client, potentially leaving the buyer unaware of viable options or the steps required to explore them. It could be seen as a breach of the agent's duty to act with reasonable care and skill. A further incorrect approach would be for the agent to encourage the buyer to proceed with a standard home loan application without exploring government-backed options, even if the buyer has expressed interest in them. This would be a failure to act in the client's best interests, as it overlooks potentially more advantageous financing solutions that could reduce the financial burden on the first home buyer. The professional reasoning process for similar situations should involve a clear understanding of the agent's scope of practice. Agents should focus on providing information about property and the transaction process, and when financial matters arise, they should guide clients towards qualified financial professionals. This involves active listening to the client's needs and interests, identifying potential areas where specialized advice is required, and facilitating access to that advice. It is crucial to maintain transparency about the agent's role and limitations, ensuring the client understands that the agent is a facilitator of property transactions, not a financial advisor. Question 3. Benchmark analysis indicates that the Victorian real estate market is experiencing shifts influenced by broader economic conditions. A prospective investor client is seeking your advice on purchasing a property in Melbourne, Which of the following approaches best aligns with your professional and regulatory obligations in Victoria? Option A. Focus exclusively on recent property sales figures in the specific Melbourne suburb the client is interested in, highlighting the upward trend to demonstrate market growth. Option B. Present a comprehensive overview of current Victorian economic indicators such as interest rates, inflation, and employment trends, and explain their observed impact on the local property market, discussing potential implications for the client's investment without making definitive future predictions. Option C. Provide the client with your personal forecast for property price increases over the next 5 years, based on your intuition about future economic developments. Option D. Emphasize the strong demand for properties in Melbourne and downplay any concerns about rising interest rates or inflation, assuring the client that the market is resilient. The correct answer is B. Present a comprehensive overview of current Victorian economic indicators such as interest rates, inflation, and employment trends, and explain their observed impact on the local property market, discussing potential implications for the client's investment without making definitive future predictions. Explanation. Scenario analysis. This scenario presents a professional challenge for a real estate agent in Victoria, Australia, due to the inherent volatility and interconnectedness of economic factors with the local property market. The agent must navigate the complexities of advising a client on a significant investment decision, while being mindful of external economic forces that could impact property values. The challenge lies in providing accurate, ethical, and legally compliant advice that considers both current market conditions and potential future economic shifts, without making speculative predictions or misrepresenting market realities. This requires a deep understanding of the Victorian property market's sensitivity to economic indicators and a commitment to acting in the client's best interest, as mandated by the Estate Agents Act 1980 VIC and the Australian Consumer Law. Correct approach analysis. The best professional approach involves conducting a thorough benchmark analysis of current Victorian real estate market conditions, identifying key economic indicators influencing these conditions, and then presenting this objective information to the client. This approach prioritizes transparency and informed decision-making. It involves referencing publicly available data on interest rates, inflation, employment figures, and population growth within Victoria, and explaining how these factors are currently impacting property supply, demand, and pricing in specific local areas. The agent would then discuss the potential implications of these observed trends for the client's investment goals, without offering guarantees or predictions. This aligns with the agent's duty of care and disclosure obligations under Victorian law, ensuring the client receives factual information to make their own informed judgment. Incorrect approach is analysis. Focusing solely on recent sales data without considering broader economic influences is an incomplete approach. This fails to acknowledge that past performance is not indicative of future results, especially when significant economic shifts are occurring. It risks providing a skewed perspective that might lead the client to make an investment based on an unsustainable market trend, potentially violating the agent's duty to act with reasonable care and skill. Making speculative predictions about future market performance based on anecdotal evidence or personal optimism is highly problematic. This constitutes providing financial advice without the necessary licensing and expertise, and it can be misleading and deceptive under the Australian consumer law. Such predictions can create unrealistic expectations and expose both the agent and the client to significant financial risk. Emphasizing only the positive aspects of the market while downplaying potential economic headwinds is a form of selective disclosure. This breaches the agent's ethical obligation to provide a balanced and comprehensive view. It can mislead the client into believing the market is more robust than it is, failing to meet the standard of disclosure required by the Estate Agents Act 1980, VIC, and potentially leading to a misinformed investment decision. Professional reasoning. Professionals should adopt a framework that prioritizes objective data analysis, transparent communication, and client-centric advice. This involves 1. Understanding the regulatory landscape. Familiarize yourself with the Estate Agents Act 1980 VIC and the Australian consumer law regarding disclosure, advertising, and fair conduct. 2. Data-driven assessment. Utilize reliable sources for economic and market data relevant to Victoria. 3. Client needs assessment. Clearly understand the client's investment objectives, risk tolerance, and financial situation. 4. Balanced presentation. Present both current market conditions and potential economic influences in a clear, unbiased manner. 5. Risk disclosure. Explicitly discuss potential risks and uncertainties associated with real estate investment, particularly in light of economic factors. 6. Avoidance of speculation. Refrain from making future market predictions or offering guarantees. 7. Documentation. Maintain thorough records of all advice provided and information shared. Question 4. Risk assessment procedures indicate a client in Victoria is seeking a real estate investment with the primary objective of achieving rapid capital growth. As a licensed real estate agent, which of the following approaches best aligns with your professional obligations and ethical duties when advising this client? Option A. Recommend properties that have historically shown the highest rates of capital appreciation in the immediate vicinity, based on recent sales data, without delving into the underlying economic factors or future market projections. Option B. Advise the client to invest in a property that is currently undervalued due to a distressed seller, assuming this will guarantee rapid capital growth once the market recovers, irrespective of the property's condition or long-term viability. Option C. Focus on properties that are likely to generate the highest commission for your agency, as this indicates a higher perceived value and potential for future growth, and present these as the best options for the client. Option D. Conduct a comprehensive investment analysis, including market research, property valuation, and risk assessment, to present a balanced view of potential capital growth and associated risks, ensuring the advice is tailored to the client's overall financial situation and risk tolerance. The correct answer is D. Conduct a comprehensive investment analysis, including market research, property valuation, and risk assessment, to present a balanced view of potential capital growth and associated risks, ensuring the advice is tailored to the client's overall financial situation and risk tolerance. Explanation. Scenario analysis. This scenario presents a professional challenge for a Victorian real estate agent advising a client on a significant investment. The challenge lies in balancing the client's stated desire for rapid capital growth with the agent's fiduciary duty to provide objective, well-researched advice that considers all relevant risks. The agent must navigate potential conflicts of interest, ensure compliance with the Estate Agents Act 1980 VIC and its associated regulations, and uphold ethical standards by prioritizing the client's best interests over potential personal gain or a quick sale. The pressure to meet client expectations for high returns can lead to overlooking crucial due diligence, making a robust decision-making framework essential. Correct approach analysis. The best professional approach involves conducting a comprehensive investment analysis that prioritizes the client's long-term financial well-being and risk tolerance. This includes thoroughly researching the property's market value, potential for rental yield, local economic factors, zoning regulations, and any potential development restrictions in Victoria. The agent should present a balanced view, clearly outlining both the potential for capital growth and the associated risks, such as market downturns, unexpected maintenance costs, or changes in local infrastructure. This approach aligns with the agent's duty of care and skill under Victorian law, requiring them to act honestly and diligently in the best interests of their client. It also adheres to the ethical obligations of real estate professionals to provide accurate and unbiased advice, ensuring the client can make an informed decision. Incorrect approaches analysis. Focusing solely on the client's stated desire for rapid capital growth without thorough due diligence is professionally unacceptable. This approach risks misrepresenting the investment's true potential and failing to adequately inform the client of inherent risks, potentially violating the agent's duty to act in the client's best interests. It could also lead to the agent recommending a property that is unsuitable for the client's risk profile, thereby breaching their duty of care. Recommending a property based on anecdotal evidence or a gut feeling about future market trends without supporting data or objective analysis is also professionally unsound. This disregards the need for evidence-based decision-making and exposes the client to undue risk. Such an approach fails to meet the standard of care expected of a licensed real estate agent in Victoria, who is obligated to provide informed advice. Prioritizing a property that offers the highest commission for the agent, even if it doesn't align with the client's stated goals or risk tolerance, represents a serious ethical and regulatory breach. This constitutes a conflict of interest and violates the agent's fiduciary duty to act solely in the client's best interests. Victorian regulations strictly prohibit agents from placing their own interests above those of their clients. Professional reasoning. Professionals should adopt a structured decision-making framework that begins with a thorough understanding of the client's objectives, risk tolerance, and financial situation. This should be followed by comprehensive due diligence on any proposed investment, including market research, property-specific analysis, and risk assessment. The agent must then present a balanced and objective analysis to the client, clearly articulating both potential benefits and risks. Transparency and clear communication are paramount throughout the process, ensuring the client is empowered to make an informed decision that aligns with their overall financial strategy. Question 5. Benchmark analysis indicates that a residential property in suburban Melbourne has several comparable properties that have recently sold in the immediate vicinity. Given these market conditions, which valuation method would a licensed Victorian real estate agent most appropriately employ to determine the property's current market value? Option A. Comparative market analysis. Option B. A combination of all three approaches without specific justification for each. Option C. Income approach. Option D. Cost approach. The correct answer is A. Comparative market analysis. Explanation. Scenario analysis. This scenario presents a professional challenge for a Victorian licensed real estate agent tasked with providing a valuation for a property. The challenge lies in selecting the most appropriate valuation method when faced with differing market conditions and property characteristics. A failure to apply the correct methodology can lead to an inaccurate valuation, potentially misleading the client, contravening ethical obligations, and violating the Estate Agents Act 1980 VIC and its associated regulations, particularly concerning professional conduct and the duty of care owed to clients. The agent must exercise sound judgment to ensure the valuation reflects current market realities and adheres to professional standards. Correct approach analysis. The most appropriate approach in this scenario is the comparative market analysis. This method involves comparing the subject property to similar properties that have recently sold in the same or a very similar location. Adjustments are made for differences in features, condition, and size to arrive at an estimated market value. This approach is considered best practice in Victoria for residential property valuations because it directly reflects what buyers are currently willing to pay in the local market. The Estate Agents Act 1980 VIC and the Estate Agents Professional Conduct Regulations 2018 mandate that agents act honestly and competently. Providing a valuation based on direct market evidence aligns with these duties, ensuring the valuation is realistic and defensible. It is the most reliable indicator of current market value for properties where sufficient comparable sales data is available. Incorrect approaches analysis. Using the income approach would be professionally unacceptable in this context. This method is primarily used for investment properties, where the valuation is based on the potential rental income and yield. Applying it to a standard residential property without significant investment potential would ignore the primary drivers of value for such a property, which are typically owner-occupier demand and comparable sales. This failure to use the most relevant method constitutes a lack of competence and could mislead the client about the property's true market value, potentially breaching the agent's duty of care. Employing the cost approach would also be inappropriate and professionally unsound. This method estimates value by calculating the cost to replace the property minus depreciation plus land value. While useful for unique properties, new constructions, or insurance valuations, it does not accurately reflect current market demand or what a willing buyer would pay for an established residential property in Victoria. It ignores the subjective elements of buyer preference and the dynamics of the local sales market, leading to a potentially inflated or deflated valuation that does not align with market realities. This misapplication of a valuation method would demonstrate a lack of professional judgment and could result in a misleading valuation, violating regulatory expectations. Professional reasoning. When faced with providing a property valuation, a Victorian licensed real estate agent should first assess the nature of the property and the availability of market data. For most residential properties, the comparative market analysis is the primary and most reliable method due to its direct reflection of current market activity. If the property has significant investment potential, the income approach may be considered as a supplementary method. The cost approach is generally reserved for specialized circumstances. The agent's professional duty requires them to select the method that most accurately and reliably reflects the property's market value, ensuring transparency and competence in their advice to the client, in accordance with the Estate Agents Act 1980, VIC. Question 6. The control framework reveals that a client in Victoria has entered into a contract to purchase a property, but has not yet had their name registered on the title. The agent is aware that the client has paid a significant deposit and believes they have a strong, equitable interest in the property. What is the most appropriate advice to provide the client regarding the security of their ownership rights in this situation? Option A. Advise the client that while they have an equitable interest, their ownership rights are not fully secured until registration, and they should exercise caution with any actions that assume full proprietary rights. Option B. Advise the client that their equitable interest, backed by a substantial deposit, provides the same level of security as a registered title under Victorian law. Option C. Inform the client that they can immediately commence significant structural renovations on the property, as their equitable interest grants them full control over the property. Option D. Proceed with marketing the property for sale by the client, assuming their ownership is as secure as a registered proprietor, without further investigation into the title's status. The correct answer is A. Advise the client that, while they have an equitable interest, their ownership rights are not fully secured until registration, and they should exercise caution with any actions that assume full proprietary rights. Explanation. The control framework reveals a common challenge in Victorian real estate transactions: navigating the complexities of property rights and ownership when dealing with unregistered interests. This scenario is professionally challenging because it requires a deep understanding of the Torrens system as applied in Victoria, specifically the limitations on unregistered interests and the protections afforded to registered proprietors. Careful judgment is required to balance the rights of the parties involved and ensure compliance with the Transfer of Land Act 1958. VIC. The best professional approach involves diligently verifying the registered title and advising the purchaser that their interest will only be fully protected upon registration. This means clearly communicating that, while an unregistered interest may exist, it is vulnerable to prior registered interests and other claims. The professional must explain that the purchaser's rights are contingent on the registration process and that they should not assume full ownership or security until this is complete. This approach aligns with the principles of the Torrens system, which prioritizes indefeasibility of title for registered proprietors. It also adheres to ethical obligations to provide clear, accurate, and comprehensive advice to clients, managing their expectations regarding the security of their property rights. An incorrect approach would be to advise the purchaser that their unregistered interest is as secure as a registered one. This fails to acknowledge the fundamental principle of indefeasibility of title under the Transfer of Land Act 1958, VIC, which generally protects registered proprietors against unregistered claims unless specific exceptions apply, e.g., fraud. Advising otherwise misrepresents the legal standing of an unregistered interest and exposes the purchaser to significant risk. Another incorrect approach would be to proceed with the transaction without thoroughly investigating the registered title and advising the purchaser on the implications of their unregistered interest. This demonstrates a lack of due diligence and a failure to uphold professional standards. It neglects the duty to inform the client about potential risks and the steps necessary to secure their property rights. A further incorrect approach would be to suggest that the purchaser can immediately exercise all rights of a registered owner, such as commencing significant renovations or subdividing the property, based solely on an unregistered interest. This is legally unsound and ethically irresponsible, as the purchaser's rights are not fully established until registration. Such advice could lead to substantial financial and legal complications for the purchaser. Professionals should employ a decision-making framework that prioritizes understanding the client's objectives, thoroughly investigating the legal status of the property under Victorian law, specifically the Transfer of Land Act 1958, clearly communicating the risks and benefits associated with different stages of ownership, and ensuring all advice is compliant with regulatory requirements and ethical standards. This involves a proactive approach to risk management and client education. Question 7. Cost-benefit analysis shows that a landlord in Victoria is preparing a residential lease agreement for a new tenant. They have discussed a 12-month fixed term with the tenant, but the landlord also wants to include a provision that allows them to end the lease early if they decide to sell the property, with only 2 months' notice. Which approach best reflects best practice and compliance with Victorian residential tenancy laws? Option A. Draft a written lease agreement clearly stating a 12-month fixed term, and a specific clause allowing the landlord to terminate the lease early with 2 months' written notice if the property is listed for sale, provided this clause is mutually agreed upon and understood by both parties. Option B. Include a clause in the written lease that grants the landlord the absolute right to terminate the lease at any time for any reason with 1 month's notice, without needing to provide a specific justification. Option C. Draft a written lease agreement for a 12-month fixed term and assume that the tenant will understand the landlord's need to sell and will vacate with minimal notice if required, without explicitly stating this in the agreement. Option D. Rely on a verbal agreement with the tenant that they can leave the lease early if needed, while the written lease specifies a 12-month term, assuming this flexibility will be honored. The correct answer is A. Draft a written lease agreement clearly stating a 12-month fixed term and a specific clause allowing the landlord to terminate the lease early with 2 months' written notice if the property is listed for sale, provided this clause is mutually agreed upon and understood by both parties. Explanation. Cost-benefit analysis shows that understanding the nuances of lease agreements in Victoria is crucial for both landlords and tenants to avoid disputes and ensure compliance with the Residential Tenancies Act 1997, VIC. This scenario is professionally challenging because it requires a landlord to balance their desire for a long-term, stable tenancy with the tenant's potential need for flexibility, all while adhering to Victorian residential tenancy laws. Careful judgment is required to draft a lease that is both legally sound and practically beneficial for all parties. The best professional practice involves clearly defining the lease term and any options for renewal or early termination within the written agreement, ensuring both parties understand their rights and obligations from the outset. This approach aligns with the Residential Tenancies Act 1997, VIC, which mandates that certain terms of a residential tenancy agreement must be in writing. Specifically, Section 29 of the Act requires that a residential rental agreement must be in writing and that the landlord must provide a copy to the tenant. By clearly outlining the fixed term and the conditions for early termination, the landlord is proactively addressing potential future conflicts and ensuring transparency, which is a cornerstone of ethical landlord-tenant relationships and legal compliance in Victoria. An approach that relies on a verbal agreement for a longer term than the written lease, with the understanding that the tenant can leave early without penalty, is professionally unacceptable. This fails to meet the written requirement for residential tenancy agreements under Victorian law and creates ambiguity. It exposes the landlord to potential disputes regarding rent recovery and the tenant to uncertainty about their obligations, contravening the spirit and letter of the Residential Tenancies Act 1997, VIC, regarding clear contractual terms. Another professionally unacceptable approach is to include a clause allowing the landlord to terminate the lease early for any reason with minimal notice, without a corresponding right for the tenant. This is not only ethically questionable, but also likely to be unenforceable under Victorian tenancy law, which provides specific grounds and notice periods for landlords seeking to end a tenancy. Such a clause creates an imbalance of power and disregards the tenant's right to peaceful enjoyment of the property, as protected by general contract law principles and implied terms within residential tenancy agreements. Finally, an approach that states the lease is month-to-month, despite the landlord and tenant discussing a 12-month commitment, without explicitly documenting this longer term or the month-to-month arrangement, is also professionally flawed. This creates a significant discrepancy between the parties' expectations and the legal document. It fails to provide clarity and can lead to misunderstandings and legal challenges, as the written agreement will be the primary determinant of the tenancy terms under Victorian law. Professionals should employ a decision-making framework that prioritizes clear, written communication and strict adherence to the Residential Tenancies Act 1997, VIC. This involves thoroughly discussing all terms with the prospective tenant, ensuring all agreed-upon conditions, including lease duration, renewal options, and termination clauses, are accurately reflected in the written agreement. Seeking legal advice when drafting or reviewing complex lease terms is also a critical step in ensuring compliance and mitigating risk. Question 8. During the evaluation of a property located in regional Victoria, a real estate agent is presented with a property that features a substantial dwelling, a large shed suitable for light manufacturing, and several hectares of cleared land currently used for hobby farming. The vendor has indicated they primarily use the land for personal enjoyment and occasional small-scale produce sales. Considering the Estate Agents Act 1980 VIC and common industry practices in Victoria, which approach best ensures accurate classification and ethical marketing of this property. Option A. Classify the property based on a comprehensive assessment of its primary use, considering the dwelling, the shed's potential for light manufacturing, and the agricultural land, determining which aspect is most dominant or defining for its current or intended primary purpose. Option B. Classify the property as industrial due to the presence of the shed, even though its use is currently limited and not the primary activity. Option C. Categorize the property as agricultural, highlighting the potential for larger-scale farming operations to attract a wider range of buyers. Option D. Market the property exclusively as residential, focusing on the dwelling and the lifestyle aspects of the land, as the vendor primarily uses it for personal enjoyment. The correct answer is A. Classify the property based on a comprehensive assessment of its primary use, considering the dwelling, the shed's potential for light manufacturing, and the agricultural land, determining which aspect is most dominant or defining for its current or intended primary purpose. Explanation. Scenario analysis. This scenario presents a professional challenge for a Victorian real estate agent because it requires them to accurately classify a property for the purpose of marketing and disclosure, adhering to the specific definitions and regulations of Victoria. Misclassification can lead to misrepresentation, breach of contract, and potential legal and financial repercussions for both the agent and the vendor. The agent must demonstrate a thorough understanding of the different categories of real estate as defined under Victorian law and industry, best practices to ensure compliance and ethical conduct. Correct approach analysis. The best professional practice involves a comprehensive evaluation of the property's primary use and characteristics, aligning with the definitions provided by the Estate Agents Act 1980 (VIC) and relevant industry guidelines. This approach necessitates considering the dominant purpose for which the property is occupied or intended to be occupied. For a property with multiple potential uses, the agent must determine which use is most significant or defining. This involves a detailed inspection, review of any existing documentation, e.g., council zoning, previous sale records, and potentially consultation with the vendor regarding their intended use or the property's history. The agent must then select the classification that most accurately reflects this primary use. This ensures transparency and compliance with disclosure obligations, preventing misleading advertising and protecting consumer interests. Incorrect approaches analysis. Marketing the property solely based on the vendor's stated intention without independent verification or consideration of the property's physical characteristics and zoning is an ethical and regulatory failure. This approach risks misrepresenting the property's true nature and potential uses, potentially contravening the Estate Agents Act 1980 (VIC), which mandates truthful and accurate representations. Classifying the property based on a secondary or potential future use that is not currently established or the primary function of the property is also problematic. This can lead to misleading advertising and may not align with the property's current zoning or established use, potentially violating consumer protection laws and industry codes of conduct. Focusing only on the most lucrative or desirable classification without a factual basis or thorough investigation is a clear breach of ethical duties. This approach prioritizes potential commission over accurate representation and the client's best interests, which is contrary to the fiduciary duties owed by an agent and the requirements of the Estate Agents Act 1980 (VIC). Professional reasoning. Professionals in Victoria should adopt a systematic approach to property classification. This involves 1. Understanding the definitions of residential, commercial, industrial, and agricultural properties as per Victorian legislation and industry standards. 2. Conducting a thorough physical inspection of the property to assess its current state and primary features. 3. Reviewing all available documentation, including council zoning certificates, planning permits, and previous sale particulars. 4. Discussing the property's history and intended use with the vendor, but critically evaluating this information against objective evidence. 5. Determining the dominant use or purpose of the property. 6. Selecting the classification that most accurately and truthfully reflects this dominant use for all marketing and disclosure purposes. 7. Documenting the reasoning behind the chosen classification. Question 9. What factors should a real estate agent in Victoria consider when advising a client on the current phase of the real estate cycle and its implications for their property decisions? Option A. A comprehensive analysis of Victorian economic indicators, local supply and demand dynamics, historical market performance, and the client's personal financial objectives and risk tolerance. Option B. Primarily focusing on recent media reports and the general sentiment expressed by other real estate agents in the area. Option C. Relying on personal intuition and past experiences without validating with current market data. Option D. Recommending a specific investment strategy based on the assumption that past growth will continue indefinitely. The correct answer is A. A comprehensive analysis of Victorian economic indicators, local supply and demand dynamics, historical market performance, and the client's personal financial objectives and risk tolerance. Explanation. Scenario analysis. This scenario is professionally challenging because it requires a real estate agent in Victoria to interpret and apply knowledge of real estate cycles and trends to advise a client. The agent must move beyond simply stating market conditions to providing actionable, ethically sound advice that aligns with the client's best interests and the regulatory obligations under Victorian law. Misinterpreting trends or providing advice based on incomplete or biased information could lead to significant financial detriment for the client and potential breaches of professional conduct. The agent's duty of care and disclosure obligations are paramount. Correct approach analysis. The best professional practice involves a comprehensive analysis of current and historical Victorian real estate market data, considering both macroeconomic factors, interest rates, inflation, employment, and microeconomic factors specific to the Victorian property market, population growth, infrastructure development, local supply and demand dynamics. This analysis should then be used to identify prevailing trends, e.g., growth, stagnation, decline, and potential future trajectories. The agent must then communicate these findings clearly and objectively to the client, highlighting potential opportunities and risks associated with different market phases, and tailoring advice to the client's specific financial situation, investment goals, and risk tolerance. This approach aligns with the agent's duty to act honestly and professionally, as mandated by the Estate Agents Act 1980 VIC, and the Consumer Affairs Victoria (CAV) guidelines, which emphasize providing accurate information and acting in the best interests of the client. Incorrect approaches analysis. Focusing solely on recent positive price growth without considering the broader economic context or potential for market correction is an incomplete and potentially misleading approach. This ignores the cyclical nature of real estate and could lead to advising a client to enter a market at its peak, exposing them to significant risk. This fails to meet the duty of care and disclosure requirements. Advising a client based on anecdotal evidence or the opinions of other agents without independent, data-driven analysis is unprofessional and unreliable. This approach lacks the rigor required to provide sound advice and could lead to decisions based on speculation rather than informed judgment, potentially breaching the agent's obligation to provide competent advice. Recommending a specific course of action, e.g., buy now or sell immediately, without a thorough understanding of the client's individual circumstances and a balanced presentation of market risks and opportunities is prescriptive and potentially harmful. This oversteps the agent's role from advisor to decision-maker for the client and fails to uphold the client's autonomy and best interests. Professional reasoning. Professionals should adopt a data-driven, client-centric approach. This involves 1. Thoroughly researching and analyzing relevant market data for the specific Victorian region. 2. Identifying and understanding the drivers of current and potential future market trends. 3. Objectively presenting findings to the client, including potential risks and opportunities. 4. Collaboratively developing a strategy that aligns with the client's unique financial goals and risk profile. 5. Maintaining transparency and ensuring the client makes informed decisions. This process ensures compliance with ethical duties and regulatory requirements in Victoria. Question 10. Stakeholder feedback indicates a recurring issue where buyers in Victoria, Australia, sometimes rely on verbal assurances from agents regarding critical contractual terms, only to find these terms differ in the written contract. Consider a scenario where a buyer, MS, Anya Sharma, is purchasing a property in Melbourne. During negotiations, the agent verbally assured MS Sharma that the settlement period would be 30 days. However, upon receiving the contract of sale, MS Sharma notices the settlement period is stipulated as 60 days. MS Sharma contacts the agent, expressing her concern and stating her belief that the 30-day settlement is the agreed-upon term. If MS Sharma were to ask for your professional advice on how to proceed, which of the following approaches would best uphold her interests and comply with Victorian real estate regulations? Option A. Advise MS Sharma to sign the contract as is based on the verbal assurance, and then immediately lodge a formal complaint with the Victorian Property Fund against the agent for misrepresentation. Option B. Advise MS Sharma to proceed with the purchase based on the verbal assurance of a 30-day settlement, and to simply ignore the 60-day clause in the written contract, assuming it is a clerical error. Option C. Advise MS Sharma to carefully review the written contract of sale, highlighting the discrepancy in the settlement period, and strongly recommend she seek independent legal advice from a solicitor or conveyancer to understand the implications of the written term and discuss potential options for amendment before signing. Option D. Advise MS Sharma that the verbal agreement for a 30-day settlement is legally binding, and she should proceed with signing the contract, assuming the seller will honor the verbal commitment. The correct answer is C. Advise MS Sharma to carefully review the written contract of sale, highlighting the discrepancy in the settlement period, and strongly recommend she seek independent legal advice from a solicitor or conveyancer to understand the implications of the written term and discuss potential options for amendment before signing. Explanation. Scenario analysis. This scenario presents a common challenge in Victorian real estate transactions where a buyer, relying on a verbal assurance regarding a significant contractual term, the settlement date, faces a potential dispute when the written contract differs. The professional challenge lies in balancing client expectations with the strict legal requirements of written contracts and the agent's duty of care. Misinterpreting or miscommunicating contractual terms can lead to significant financial and legal repercussions for both buyer and seller and expose the agent to liability. Careful judgment is required to ensure all parties understand their obligations and that the contract accurately reflects the agreed terms. Correct approach analysis. The best professional practice involves advising the buyer to review the written contract meticulously and to seek legal advice if any aspect, particularly the settlement date, deviates from their understanding or verbal agreements. This approach is correct because the Estate Agents Act 1980 VIC and the Sale of Land Act 1962 VIC mandate that all material terms of a sale must be in writing to be enforceable. Verbal assurances, while potentially persuasive, do not override the written contract. The agent has a duty to ensure the buyer is fully informed of the written terms and their implications, and to facilitate clarity and understanding, which includes recommending professional legal review for complex or critical clauses. Incorrect approaches analysis. Advising the buyer that the verbal agreement for a settlement date of 30 days is binding, despite the written contract stating 60 days, is professionally unacceptable. This fails to acknowledge the statute of frauds principles, which require contracts for the sale of land to be in writing to be enforceable. It misleads the buyer about the legal standing of their agreement and could lead to a breach of contract claim against them. Suggesting the buyer proceed with the purchase based solely on the verbal assurance and assume the seller will agree to amend the contract later is also professionally unsound. This approach ignores the legal reality of written contracts and the potential for disputes. It places the buyer at significant risk of financial loss and legal complications if the seller refuses to amend the contract, violating the agent's duty to act in the best interests of their client and to provide accurate advice. Recommending the buyer sign the contract and then immediately lodge a complaint against the agent for misrepresentation without first attempting to clarify the discrepancy or seek legal counsel is premature and unprofessional. While a complaint might eventually be warranted, the immediate professional obligation is to facilitate understanding and resolution of the contractual terms. This approach bypasses the necessary steps for dispute resolution and contractual clarity. Professional reasoning. Professionals should adopt a framework that prioritizes clear communication, adherence to legal requirements, and client education. When a discrepancy arises between verbal discussions and written documentation, the professional's first step should be to highlight the written contract's terms to the client. They must then strongly advise the client to read the contract thoroughly and, crucially, to seek independent legal advice regarding any clauses that are unclear or differ from their understanding. This ensures the client makes an informed decision based on legally binding documents, protecting both the client and the professional from potential liability. Question 11. Stakeholder feedback indicates a need to reinforce best practices in mortgage product recommendations for clients in Victoria. A mortgage broker is advising a first-home buyer couple who have a stable, dual-income household, a clear long-term plan to remain in their home, and express a strong preference for predictable monthly expenses. They are concerned about potential future financial shocks and wish to avoid any surprises in their mortgage repayments. Considering the couple's stated priorities and financial profile, which of the following mortgage product recommendations best aligns with their needs and regulatory obligations in Victoria? Option A. An interest-only mortgage to minimize initial repayment amounts. Option B. An adjustable-rate mortgage, where repayments may fluctuate with market interest rates. Option C. A mortgage product that offers the lowest initial interest rate regardless of its repayment structure. Option D. A fixed-rate mortgage, offering consistent repayment amounts for the entire loan term. The correct answer is D. A fixed-rate mortgage, offering consistent repayment amounts for the entire loan term. Explanation. Scenario analysis. This scenario presents a professional challenge for a Victorian mortgage broker due to the diverse financial needs and risk appetites of clients, coupled with the regulatory obligation to act in their best interests. The broker must navigate the complexities of different mortgage types to recommend a product that aligns with the client's long-term financial stability and understanding, rather than simply facilitating a transaction. Failure to do so can lead to client detriment, regulatory breaches under the National Credit Code, which applies in Victoria, and damage to the broker's reputation. Correct approach analysis. The best professional practice involves a thorough assessment of the client's financial situation, risk tolerance, and future income stability. This includes understanding their capacity to manage potential increases in repayments. A client with a stable income, a long-term commitment to the property, and a desire for predictable budgeting, a fixed-rate mortgage is the most appropriate recommendation. This approach aligns with the broker's duty under the National Credit Code to ensure that any credit contract entered into is not unsuitable for the consumer. A fixed-rate mortgage provides certainty of repayment amounts, mitigating the risk of financial stress if interest rates rise, which is crucial for long-term financial planning and homeownership. Incorrect approaches analysis. Recommending an adjustable-rate mortgage without a detailed discussion of potential repayment increases and the client's capacity to absorb them is professionally unsound. This approach fails to adequately assess suitability and could lead to the client being unable to meet their obligations if interest rates rise, potentially breaching the National Credit Code's responsible lending obligations. Suggesting an interest-only mortgage solely to lower initial repayments, without a clear and robust plan for how the principal will be repaid at the end of the interest-only period, is also a significant ethical and regulatory failure. This can leave the client with a substantial debt burden they are unprepared to manage, contravening the duty to act in the client's best interests and potentially leading to unsuitability. Proposing a product based on the broker's personal preference or a perceived ease of sale, rather than a client-centric needs analysis, demonstrates a failure to uphold professional standards and the regulatory requirements of the National Credit Code. Professional reasoning. Professionals should adopt a client-first approach. This involves active listening to understand the client's goals and concerns, conducting a comprehensive financial needs analysis, and clearly explaining the features, benefits, risks, and costs of all suitable product options. The decision-making process should prioritize client suitability and long-term financial well-being, ensuring transparency and informed consent, in line with the principles of responsible lending and the National Credit Code. Question 12. Stakeholder feedback indicates that landlords in Victoria are sometimes faced with tenants experiencing unforeseen financial hardship, leading to rent arrears. A landlord in Melbourne has a tenant who has recently lost their job and is struggling to make rent payments. The tenant has communicated their situation and expressed a desire to find a solution. What is the most appropriate course of action for the landlord to take, considering the Residential Tenancies Act 1997, VIC? Option A. Engage in open communication with the tenant to understand their situation. Explore options like a temporary rent reduction or payment plan, and if necessary, initiate the formal notice to vacate process strictly adhering to the Residential Tenancies Act 1997, VIC, timelines and requirements. Option B. Accept partial rent payments without clarifying the status of the arrears or the notice to vacate, hoping the situation resolves itself. Option C. Agree to a verbal arrangement for the tenant to defer rent payments for an indefinite period until they find new employment, without any written agreement. Option D. Immediately issue a notice to vacate to the tenant for rent arrears, as this is a standard procedure for non-payment of rent under Victorian tenancy law. Correct answer is A. Engage in open communication with the tenant to understand their situation. Explore options like a temporary rent reduction or payment plan, and if necessary, initiate the formal notice to vacate process strictly adhering to the Residential Tenancies Act 1997, VIC, timelines and requirements. Explanation. Scenario analysis. This scenario is professionally challenging because it involves a tenant who is experiencing significant personal hardship, creating a tension between the landlord's legal rights and ethical considerations. Navigating this situation requires a careful balance of adhering to the Residential Tenancies Act 1997, VIC, while also demonstrating empathy and exploring all available avenues before resorting to formal eviction proceedings. Misjudging the situation could lead to legal repercussions for the landlord, damage to their reputation, and significant distress for the tenant. Correct approach analysis. The best professional approach involves a thorough review of the lease agreement and the Residential Tenancies Act 1997, VIC, to understand the specific grounds for termination and the required notice periods. Simultaneously, engaging in open and empathetic communication with the tenant to understand the full extent of their hardship and exploring potential solutions such as a temporary rent reduction, a payment plan, or connecting them with relevant support services is crucial. If these informal resolutions are unsuccessful, then initiating the formal notice to vacate process as prescribed by the Act, ensuring all documentation and timelines are meticulously followed, is the appropriate next step. This approach prioritizes legal compliance while also attempting to mitigate hardship and explore all reasonable alternatives before formal eviction. Incorrect approaches analysis. One incorrect approach is to immediately issue a notice to vacate based solely on the missed rent payments, without attempting any communication or exploring alternative solutions. This fails to acknowledge the tenant's stated hardship and bypasses the spirit of the Residential Tenancies Act 1997, VIC, which encourages resolution where possible. It also risks a VCAT hearing where the tribunal may consider the landlord's lack of attempt to resolve the issue when making a decision. Another incorrect approach is to accept rent payments after the notice to vacate has been issued without clarifying the status of the notice. This can create ambiguity and potentially invalidate the notice, requiring the landlord to restart the process. It also fails to provide clear communication to the tenant about their obligations and the landlord's intentions. A further incorrect approach is to agree to a verbal arrangement for rent deferral without documenting it in writing, and without understanding the long-term implications for the lease. This lack of formalization can lead to disputes and misunderstandings, potentially undermining the landlord's ability to enforce the lease terms or pursue eviction if the situation does not improve. Professional reasoning. Professionals should adopt a structured decision-making process that begins with a comprehensive understanding of the relevant legislation. In this case, the Residential Tenancies Act 1997, VIC. This should be followed by an assessment of the factual circumstances, including the tenant's situation and the landlord's objectives. Empathy and open communication are vital tools for exploring all possible resolutions before escalating to formal legal action. Documentation of all communications and agreements is paramount to protect all parties involved and ensure compliance with legal requirements. Question 13. Process analysis reveals that a real estate agent in Victoria is marketing a residential property for a vendor who explicitly instructs the agent not to show the property to prospective buyers of a particular ethnic background. What is the most appropriate and legally compliant course of action for the agent to take in this situation? Option A. Subtly discourage prospective buyers from the specified ethnic background from pursuing the property without directly confronting the vendor's instructions. Option B. Immediately withdraw from the listing without further discussion or attempt to educate the vendor on fair housing laws. Option C. Politely inform the vendor that their instructions are unlawful under Victorian fair housing legislation and explain that the agent cannot act on discriminatory instructions, offering to market the property to all qualified buyers without prejudice. Option D. Proceed with the vendor's instructions by only showing the property to buyers who do not belong to the specified ethnic background. The correct answer is C. Politely inform the vendor that their instructions are unlawful under Victorian fair housing legislation and explain that the agent cannot act on discriminatory instructions, offering to market the property to all qualified buyers without prejudice. Explanation. Scenario analysis. This scenario presents a professional challenge because real estate agents in Victoria are legally obligated to uphold fair housing principles and avoid discrimination. The challenge lies in navigating client instructions that may inadvertently or intentionally lead to discriminatory practices, requiring the agent to balance client satisfaction with legal and ethical responsibilities. Misinterpreting or ignoring these obligations can result in significant legal penalties and reputational damage. Correct approach analysis. The best professional practice involves politely but firmly educating the vendor about their legal obligations under Victorian fair housing laws, specifically the Equal Opportunity Act 2010, VIC. This approach involves explaining that refusing to sell to a prospective buyer based on their race, religion, sexual orientation, or other protected attributes is unlawful. The agent should then advise the vendor that they cannot act on instructions that would facilitate discrimination and offer to proceed with marketing the property to all qualified buyers without prejudice. This aligns with the agent's duty of care and professional conduct, ensuring compliance with the law and ethical standards. Incorrect approaches analysis. One incorrect approach involves accepting the vendor's instructions without question and selectively showing the property only to buyers who meet the vendor's discriminatory criteria. This directly violates the Equal Opportunity Act 2010, VIC. By facilitating unlawful discrimination, the agent becomes complicit in the discriminatory act, exposing themselves and their agency to legal action and severe penalties. Another incorrect approach is to attempt to subtly steer prospective buyers away from the property if they belong to a group the vendor has expressed prejudice against, without directly confronting the vendor's discriminatory stance. While this might seem like a way to avoid direct conflict, it still involves acting on discriminatory intent and can be construed as indirect discrimination, which is also prohibited under Victorian law. The agent is still failing to uphold fair housing principles. A third incorrect approach is to inform the vendor that their request is illegal, but then withdraw from the listing entirely without attempting to educate the vendor or find a lawful way to proceed. While withdrawing from a situation where illegal instructions are given is sometimes necessary, a professional agent should first attempt to guide the client towards lawful conduct. Simply walking away without explanation or further engagement fails to uphold the agent's role in promoting fair housing practices within the industry. Professional reasoning. Professionals in real estate in Victoria must adopt a proactive stance on fair housing. When faced with potentially discriminatory client instructions, the decision-making process should involve 1. Identifying the potential violation of the Equal Opportunity Act 2010 VIC or other relevant anti-discrimination legislation. 2. Prioritizing legal and ethical compliance over client demands that contravene the law. 3. Educating the client about their legal obligations and the consequences of discrimination. 4. Clearly communicating the agent's inability to act on discriminatory instructions. 5. Offering to proceed with the transaction in a lawful and non-discriminatory manner. If the client remains insistent on discriminatory practices, the agent must be prepared to cease acting for them, but only after making a genuine effort to ensure lawful conduct. Question 14. The performance metrics show a significant increase in demand for co-living spaces in Melbourne's inner north, prompting a developer to propose a new co-living facility. The developer has presented a preliminary concept that appears to align with the general character of the area, but may not strictly adhere to the specific permitted uses or development standards outlined in the local planning scheme for the subject land. What is the most appropriate initial course of action for the planning consultant advising the developer? Option A. Recommend that the developer focus on lobbying local councilors and community groups to build support for the co-living concept, with the expectation that planning approval will follow once community consensus is established. Option B. Suggest that the developer commence site preparation and construction, as the demand for co-living is high, and the project's general alignment with the area's character will likely lead to planning approval once the development is underway. Option C. Advise the developer to proceed with the development based on the perceived similarity to existing land uses in the area, assuming that minor noncompliance can be addressed through a retrospective planning permit application if necessary. Option D. Conduct a detailed review of the relevant Victorian planning provisions and the specific local planning scheme for the municipality to determine the precise zoning, permitted uses, and any applicable overlays or specific controls, and then consult with the local council's planning department to discuss the proposal and the required application process. The correct answer is D. Conduct a detailed review of the relevant Victorian planning provisions and the specific local planning scheme for the municipality to determine the precise zoning, permitted uses, and any applicable overlays or specific controls, and then consult with the local council's planning department to discuss the proposal and the required application process. Explanation. This scenario presents a professional challenge due to the inherent tension between a developer's commercial objectives and the stringent requirements of Victoria's planning scheme, specifically concerning zoning and land use regulations. Navigating these regulations requires a deep understanding of the Planning and Environment Act 1987, VIC, and the relevant local planning scheme, as well as the ability to interpret and apply them to a specific development proposal. The professional must exercise careful judgment to ensure compliance while also advising their client effectively. The correct approach involves a thorough review of the existing zoning provisions and any applicable overlays within the local planning scheme for the specific parcel of land in Melbourne's inner north. This includes identifying the permitted uses, any restrictions on development intensity, and the process for seeking amendments or permits if the proposed use is not directly permitted. The professional must then engage with the local council's planning department to understand their interpretation of the scheme and to initiate the necessary application processes, such as a planning permit application or a request for a planning scheme amendment, if significant changes are required. This approach is correct because it prioritizes adherence to the statutory framework established by the Planning and Environment Act 1987, VIC, and the local planning scheme, which are the legal instruments governing land use and development in Victoria. It acknowledges that any development must align with the objectives and provisions of the planning scheme, and that formal processes are in place to manage deviations or changes. An incorrect approach would be to proceed with the development based on a preliminary understanding of zoning, assuming that minor deviations are acceptable or can be easily rectified later. This fails to acknowledge the legal weight of the planning scheme and the potential for significant enforcement action, including stop work orders and penalties, if development proceeds without the necessary approvals. It also overlooks the ethical obligation of a planning professional to uphold the integrity of the planning system and to advise clients on the legal requirements. Another incorrect approach would be to focus solely on the developer's desired outcome without adequately investigating the planning scheme's constraints. This might involve lobbying council members or attempting to bypass standard planning processes. Such actions undermine the transparent and objective nature of planning decision-making, which is designed to balance private interests with the public interest. It also risks alienating the planning authority and creating a confrontational relationship that is detrimental to achieving a successful outcome. A further incorrect approach would be to advise the developer that a planning permit is not required because the proposed use is similar to existing uses in the vicinity, without a detailed examination of the specific zoning category and any associated conditions or restrictions. This demonstrates a lack of due diligence and a failure to understand that even seemingly similar uses can be subject to different regulatory treatments under the planning scheme. It exposes the developer to significant legal and financial risks. Professionals should adopt a decision-making process that begins with a comprehensive understanding of the relevant legislation and planning instruments. This involves meticulous research into the specific zoning, overlays, and policies applicable to the site. Following this, Consultation with the relevant planning authority is crucial to clarify any ambiguities and to understand the procedural requirements. Any proposed development must then be assessed against these established parameters, with a clear strategy for obtaining necessary approvals. Transparency and honesty with the client regarding the feasibility and regulatory pathway are paramount. Question 15. The assessment process reveals that a client is considering purchasing a property in regional Victoria that was previously used for light industrial purposes. While the property appears to be in good condition, there are no readily available records detailing its environmental history or any past remediation efforts. What is the most prudent course of action for a Victorian real estate agent acting on behalf of this client? Option A. Inform the client that environmental due diligence is outside the scope of a real estate agent's responsibilities, and they should seek advice independently. Option B. Recommend that the client simply obtain a statutory declaration from the vendor stating the property is free from environmental contamination. Option C. Advise the client to engage a qualified environmental consultant to conduct a Phase 1 environmental site assessment to identify potential contamination risks, and advise on compliance with the Environment Protection Act 2017, VIC. Option D. Proceed with the transaction, assuring the client that the lack of immediate red flags suggests no significant environmental issues exist. The correct answer is C. Advise the client to engage a qualified environmental consultant to conduct a Phase 1 environmental site assessment to identify potential contamination risks, and advise on compliance with the Environment Protection Act 2017, VIC. Explanation. The assessment process reveals a common challenge in Victorian real estate transactions, navigating the complexities of environmental regulations and their impact on property value and development potential. This scenario is professionally challenging because it requires a nuanced understanding of the Environment Protection Act 2017, VIC, and associated regulations, which can significantly affect a property's usability and marketability. Misinterpreting or overlooking these regulations can lead to substantial financial losses for clients, legal liabilities for agents, and reputational damage. Careful judgment is required to balance the client's immediate interests with long-term compliance and ethical obligations. The correct approach involves proactively identifying potential environmental risks and advising the client on the necessary steps to address them. This means thoroughly investigating the property's history, consulting relevant authorities like the Environment Protection Authority Victoria, EPA Victoria, and recommending appropriate environmental assessments or remediation if required. This approach is correct because it aligns with the agent's duty of care to their client and their obligation to act honestly and ethically under the Estate Agents Act 1980 VIC. It also ensures compliance with the principles of responsible property development and sale, acknowledging the environmental stewardship expected within Victoria. An incorrect approach would be to downplay or ignore potential environmental concerns, especially if they might deter a buyer or reduce the perceived value. This failure to disclose known or reasonably discoverable environmental issues constitutes a breach of the agent's duty to act in the best interests of their client and to provide accurate information. It also risks contravening the Environment Protection Act 2017, VIC. If the property is subject to specific environmental controls or has a history of contamination that has not been properly managed or disclosed. Another incorrect approach is to assume that a property is free from environmental issues simply because it has not been flagged by previous transactions or is located in a seemingly unaffected area. Environmental conditions can change, and historical land use may have left latent issues. Relying on assumptions rather than due diligence is a failure to exercise professional competence and can lead to significant unforeseen liabilities for the client and the agent. A further incorrect approach is to provide definitive advice on environmental compliance or remediation without the necessary expertise or qualifications. While agents can identify potential issues and recommend professional assessments, they should not act as environmental consultants. This overstepping of professional boundaries can lead to incorrect advice, which is detrimental to the client and exposes the agent to liability. Professionals should adopt a decision-making framework that prioritizes thorough due diligence, transparent communication, and expert consultation. This involves 1. Identifying potential risks, actively seeking information about the property's environmental history and current status. 2. Consulting relevant authorities and experts, engaging with EPA Victoria and qualified environmental consultants when necessary. 3. Transparent disclosure, clearly communicating all identified environmental risks and potential impacts to the client. 4. Recommending appropriate actions, advising the client on the best course of action to mitigate risks and ensure compliance. 5. Maintaining professional boundaries, recognizing the limits of one's expertise and referring clients to specialists when required. Question 16. The risk matrix shows a potential for applicant misrepresentation of financial capacity during mortgage applications in Victoria. A mortgage broker is reviewing an application where the applicant, a self-employed individual, has provided income figures that appear higher than typical for their stated business activities. The applicant is insistent that these figures are correct and has expressed concern that a more detailed verification might jeopardize their loan approval. What is the most appropriate course of action for the mortgage broker to ensure compliance with responsible lending obligations and professional ethics? Option A. Accept the applicant's self-reported income figures as accurate, given the applicant's insistence, and proceed with the application without further independent verification. Option B. Submit the application to the lender with the applicant's stated income, but omit any mention of the broker's reservations or the potential for discrepancies. Option C. Independently verify the applicant's stated income through bank statements, tax returns, and business activity statements, and clearly communicate any findings or concerns to both the applicant and the lender. Option D. Advise the applicant on how to adjust their reported expenses or income to present a more favorable financial position to the lender, while still claiming the figures are accurate. The correct answer is C. Independently verify the applicant's stated income through bank statements, tax returns, and business activity statements, and clearly communicate any findings or concerns to both the applicant and the lender. Explanation: this scenario is professionally challenging because it requires balancing the lender's need for accurate information with the borrower's potential desire to present a favorable financial picture, and the agent's duty to both parties. Misrepresenting financial information during a mortgage application process in Victoria can have severe legal and ethical consequences, impacting the integrity of the financial system and the financial well-being of individuals. Careful judgment is required to ensure compliance with the National Credit Code, NCC, and relevant Victorian property law, as well as to uphold professional standards of honesty and diligence. The best professional approach involves the mortgage broker meticulously verifying all financial information provided by the applicant, cross-referencing it with supporting documentation, and clearly disclosing any discrepancies or potential concerns to the lender. This aligns with the broker's obligations under the NCC to act in the best interests of the consumer and to ensure that credit is provided responsibly. It also upholds the principle of providing accurate and complete information to the lender, which is fundamental to the mortgage application process and risk assessment. An approach that involves accepting the applicant's self-reported income without independent verification, even if the applicant insists it is accurate, is professionally unacceptable. This fails to meet the broker's duty of care and diligence, potentially leading to the provision of credit based on inaccurate information, which contravenes responsible lending obligations under the NCC. Another unacceptable approach is to omit or downplay any identified discrepancies in the applicant's financial information when submitting the application to the lender. This constitutes a misrepresentation and a failure to disclose material facts, which can mislead the lender and result in a loan being approved that the applicant may not be able to service. This breaches ethical obligations and potentially breaches provisions of the NCC related to disclosure. Finally, an approach that involves advising the applicant on how to present their financial situation in a way that might be misleading, even if not outright false, is also professionally unacceptable. This could involve suggesting the applicant exclude certain expenses or inflate asset values to improve their borrowing capacity. Such advice undermines the integrity of the application process and violates the broker's duty to act honestly and in the best interests of the consumer, as well as the lender's need for accurate risk assessment. Professionals should employ a decision-making framework that prioritizes transparency, accuracy, and compliance. This involves a thorough understanding of the NCC and relevant Victorian property regulations, a commitment to verifying all information, and a willingness to communicate any concerns or discrepancies openly with both the applicant and the lender. Ethical considerations, such as the duty to act in the best interests of the consumer and to avoid misleading conduct, should guide every step of the process. Question 17. The audit findings indicate that a real estate agent operating in Victoria has simultaneously acted as a buyer's agent for a client seeking to purchase a property in Melbourne and as the seller's agent for a different property in Geelong, without explicitly informing either client of their dual representation. What is the most appropriate course of action for the agent to ensure compliance with Victorian real estate regulations? Option A. Continue with both transactions, assuming that as the properties are in different locations and for different clients, there is no actual conflict of interest that requires disclosure. Option B. Advise the seller that they will no longer be representing them due to a perceived conflict without further explanation and continue to represent the buyer. Option C. Inform the buyer verbally about the dual representation and proceed, as the primary focus is on securing the best outcome for the buyer. Option D. Immediately disclose the potential conflict of interest to both the buyer and the seller in writing, detailing the nature of the dual representation and obtaining their informed written consent before continuing with either transaction. The correct answer is D. Immediately disclose the potential conflict of interest to both the buyer and the seller in writing, detailing the nature of the dual representation and obtaining their informed written consent before continuing with either transaction. Explanation. The audit findings indicate a potential breach of trust and professional conduct, making this scenario professionally challenging. The agent's dual role as both a buyer's agent and a seller's representative for different properties simultaneously, without full disclosure and consent, creates a significant conflict of interest. This requires careful judgment to ensure compliance with the Estate Agents Act 1980 VIC and the Estate Agents Professional Conduct Regulations 2018 VIC, which mandate honesty, integrity, and the avoidance of conflicts of interest. The correct approach involves transparently disclosing the potential conflict of interest to all parties involved and obtaining their informed consent in writing before proceeding. This approach upholds the agent's fiduciary duty to their clients and adheres to the principles of good faith and fair dealing expected under Victorian real estate law. Specifically, Regulation 10 of the Estate Agents Professional Conduct, Regulations 2018 VIC, requires agents to avoid conflicts of interest and, where unavoidable, to disclose them fully and obtain written consent. This proactive disclosure ensures that clients are aware of any situation that might compromise the agent's impartiality and allows them to make informed decisions about continuing the professional relationship. An incorrect approach would be to proceed with representing both parties without full disclosure, assuming that the properties are unrelated and therefore no conflict exists. This fails to acknowledge the inherent risk of divided loyalty and the potential for information gained from one client to inadvertently or intentionally benefit another, or to disadvantage one client in favor of the other. Such conduct directly contravenes the duty of care and the obligation to act in the best interests of each client, as stipulated by the Estate Agents Act 1980 VIC. Another incorrect approach would be to only disclose the conflict verbally to one party, or to disclose it after the transactions have commenced. This is insufficient as the regulations require written consent, and delaying disclosure undermines the principle of informed consent. It also suggests a lack of commitment to transparency and could be interpreted as an attempt to circumvent regulatory requirements. A further incorrect approach would be to cease representing one client abruptly without proper notice or handover, in an attempt to avoid the conflict after it has been identified. While this might seem like a solution, it can still breach contractual obligations and professional duties owed to the client being terminated, potentially leading to claims of negligence or breach of contract. The professional reasoning process should involve identifying potential conflicts early, assessing their severity, and then implementing a strategy of full disclosure and informed consent, or if the conflict is irreconcilable, seeking to withdraw from representation in a manner that minimizes harm to all parties and complies with all legal and ethical obligations. Question 18. Market research demonstrates that a property listed with your agency in Victoria is attracting significant interest, and you have just been approached directly by a potential buyer who is willing to make an offer significantly above the asking price, but they have explicitly requested that this offer be kept confidential from the vendor for a short period to explore an off-market transaction. What is the most appropriate course of action for the real estate agent? Option A. Advise the vendor to reject the offer as it is being made outside of the standard listing process and could complicate the sale. Option B. Proceed with the off-market transaction as requested by the buyer, ensuring the vendor receives the agreed-upon commission. Option C. Immediately inform the vendor of the direct offer and the potential buyer's interest, seeking their instructions on how to proceed. Option D. Inform the vendor that there is interest in an off-market sale, but do not disclose the specific offer amount or the buyer's identity until further negotiations. Correct answer is C. Immediately inform the vendor of the direct offer and the potential buyer's interest, seeking their instructions on how to proceed. Explanation. Scenario analysis. This scenario presents a professional challenge due to the inherent conflict between a licensee's duty to their client and the potential for personal gain. The licensee must navigate the ethical and legal obligations to disclose material facts and act in the best interests of their vendor, while also considering the implications of a potential off-market sale that could benefit them personally. The Victorian Estate Agents Act 1980 and its associated regulations, along with the professional conduct rules of the Real Estate Institute of Victoria, REV, are paramount in guiding this decision-making process. Careful judgment is required to ensure transparency, fairness, and compliance with all legal and ethical standards. Correct approach analysis. The best professional practice involves immediately and fully disclosing the potential buyer's interest and the offer to the vendor. This approach aligns directly with the licensee's fiduciary duty to their client, which mandates acting in the vendor's best interests and providing them with all material information relevant to the sale. Under the Estate Agents Act 1980, VIC, agents have a duty to disclose all offers received, regardless of whether they are made through the agent or directly. Furthermore, ethical guidelines require agents to avoid any situation where their personal interests conflict with those of their client. By presenting the offer transparently, the licensee upholds these obligations, allowing the vendor to make an informed decision. Incorrect approaches analysis. One incorrect approach involves proceeding with the sale without informing the vendor about the direct offer, hoping to secure a commission from both parties or a private sale. This constitutes a serious breach of the licensee's fiduciary duty to the vendor and violates the Estate Agents Act 1980, VIC, regarding disclosure of offers. It also creates a clear conflict of interest, as the licensee is prioritizing their own potential gain over their client's best interests. Another incorrect approach is to inform the vendor, but only mention the possibility of an off-market sale without disclosing the specific offer received. This is a partial disclosure and still fails to provide the vendor with all material facts necessary to make an informed decision. The licensee is withholding crucial information about a concrete offer, which is a breach of their duty of utmost good faith and transparency. A further incorrect approach is to advise the vendor to reject the offer outright without presenting it for their consideration. This preempts the vendor's right to evaluate all proposals and is a direct contravention of the agent's obligation to present all offers. The licensee is making a decision on behalf of the vendor, which is outside their scope of authority and a failure to act in the vendor's best interests. Professional reasoning. Professionals in this situation should follow a clear decision-making process. 1. Identify any potential conflicts of interest. 2. Prioritize the client's best interest above all else. 3. Disclose all material information and offers to the client promptly and fully. 4. Seek clear instructions from the client based on the disclosed information. 5. Ensure all actions comply with relevant legislation, such as the Estate Agents Act 1980 VIC and professional conduct rules. 6. Maintain transparency and honesty throughout the transaction. Question 19. Market research demonstrates that a real estate agency in Victoria is experiencing challenges in accurately and efficiently managing its client trust accounts, particularly in relation to budgeting, reporting, and record-keeping. The agency is considering several approaches to address these issues. Which approach best ensures compliance with the Estate Agents Act 1980 VIC and its associated regulations? Option A. Engage an external bookkeeper who handles general accounting for the agency, assuming they will manage trust account compliance without specific oversight or verification of their understanding of Victorian trust accounting laws. Option B. Maintain all trust account records using manual spreadsheets and paper-based ledgers, with reconciliations performed only when requested by the Business Licensing Authority. Option C. Continue using a general-purpose accounting software, with manual adjustments made to accommodate trust account transactions, and rely on periodic manual reconciliations. Option D. Implement a specialized trust accounting software designed to meet the specific requirements of Victorian real estate trust accounts, ensuring automated reconciliation and compliant reporting. The correct answer is D. Implement a specialized trust accounting software designed to meet the specific requirements of Victorian real estate trust accounts, ensuring automated reconciliation and compliant reporting. Explanation: this scenario presents a common implementation challenge in financial management for real estate agencies in Victoria, specifically concerning the accurate and timely reporting of trust account transactions. The challenge lies in balancing the need for efficient record keeping with the strict legal and ethical obligations imposed by the Estate Agents Act 1980 VIC and its associated regulations. Failure to maintain meticulous records can lead to breaches of trust, regulatory sanctions, and damage to the agency's reputation. Careful judgment is required to select a system that not only facilitates daily operations, but also ensures absolute compliance. The most appropriate approach involves implementing a dedicated trust accounting software that is specifically designed to comply with the Estate Agents Act 1980 VIC and the Estate Agents Professional Conduct Regulations 2018 VIC. This software should automate the reconciliation process, generate required reports directly from the trust ledger, and maintain an audit trail of all transactions. This is correct because it directly addresses the regulatory requirements for trust accounts, which mandate accurate and contemporaneous record keeping, regular reconciliation, and the ability to produce specific reports for auditing purposes. The Estate Agents Act 1980 VIC places a high burden on estate agents to manage trust funds with integrity, and using a compliant software system is the most robust way to meet these obligations. It ensures that all transactions are recorded accurately, that the trust account is reconciled at least monthly, and that the agency can readily provide the necessary documentation to the Business Licensing Authority, BLA, or auditors. An approach that relies solely on a general-purpose accounting software without specific trust accounting modules or customization for Victorian regulations is professionally unacceptable. This is because general accounting software may not have the built-in controls or reporting capabilities required by the Estate Agents Act 1980 VIC for trust accounts, could lead to commingling of funds, inaccurate reconciliation, and the inability to generate the specific trust account statements and audit trails mandated by law. This failure to adhere to specific trust accounting provisions constitutes a breach of professional conduct and regulatory requirements. Another professionally unacceptable approach is to maintain trust account records manually in spreadsheets without any integrated accounting system. While seemingly cost-effective, this method is highly prone to human error, making accurate reconciliation difficult and time-consuming. It significantly increases the risk of misallocating funds, failing to meet reconciliation deadlines, and being unable to produce the detailed, auditable records required by the Estate Agents Act 1980 VIC. This lack of a robust system undermines the integrity of the trust account and exposes the agency to serious regulatory penalties. Finally, an approach that delegates trust accounting responsibilities to an external bookkeeper without ensuring they are fully conversant with and equipped to handle the specific requirements of the Estate Agents Act 1980 VIC and its associated regulations is also problematic. While outsourcing can be beneficial, the ultimate responsibility for compliance rests with the licensed estate agent. If the bookkeeper lacks the necessary expertise or uses inadequate systems, the agency remains liable for any breaches. This highlights the need for due diligence in selecting and overseeing any third-party service provider involved in trust account management. Professionals should adopt a decision-making process that prioritizes regulatory compliance and risk mitigation. This involves thoroughly understanding the specific legal and ethical obligations of their jurisdiction, evaluating available tools and systems against these requirements, and implementing robust internal controls. Regular training and auditing of financial processes are essential to ensure ongoing compliance and to identify and address any potential issues proactively. Question 20. Compliance review shows a real estate agent in Victoria is advising a client on the potential future capital growth of a property in the Melbourne metropolitan area. The agent has gathered data on historical capital growth rates over the past 5 years, current interest rates, and projected interest rate changes for the next 2 years, as well as local vacancy rates and new dwelling approvals. What is the most professionally sound approach for the agent to project the future capital growth rate of the property? Option A. Project future growth based solely on the capital growth experienced in the last 12 months, assuming this trend will continue. Option B. Use the average annual capital growth rate from the last 5 years as the sole predictor of future growth. Option C. Apply national average capital growth rates to the property, assuming Victoria's market will mirror national performance. Option D. Calculate the average annual capital growth rate over the past 5 years. Adjust it based on current and projected interest rate movements, and then factor in local supply and demand dynamics and broader Victorian economic indicators. The correct answer is D. Calculate the average annual capital growth rate over the past 5 years, adjust it based on current and projected interest rate movements, and then factor in local supply and demand dynamics and broader Victorian economic indicators. Explanation. Scenario analysis. This scenario presents a professional challenge for a Victorian real estate agent due to the inherent volatility of the Melbourne housing market and the need to accurately forecast future property values. Misjudging market trends can lead to significant financial implications for clients, potentially resulting in overinvestment or missed opportunities. The agent must balance providing realistic projections with client expectations, all while adhering to ethical obligations and the regulatory framework governing property valuations in Victoria. The challenge lies in translating complex economic indicators into actionable, defensible advice. Correct approach analysis. The best professional practice involves a comprehensive analysis that integrates multiple economic factors and market-specific data. This approach acknowledges that property values are influenced by a confluence of forces, not a single metric. It requires the agent to 1. Calculate the projected annual capital growth rate by averaging the historical growth rates over the past 5 years, weighted by recent performance. 2. Incorporate current interest rate trends and projected future changes, assessing their impact on borrowing capacity and buyer demand. 3. Factor in local supply and demand dynamics, such as new development pipelines and vacancy rates. 4. Consider broader economic indicators like inflation, employment figures, and population growth specific to Victoria. This multifaceted approach aligns with the principles of providing informed advice under the Estate Agents Act 1980 VIC and the Consumer Affairs Victoria Guidelines, which mandate agents to act honestly and competently, and to avoid misleading representations. It ensures that the valuation is robust, defensible, and grounded in a thorough understanding of the Victorian real estate market. Incorrect approaches analysis. An approach that solely relies on the average historical capital growth rate without considering current economic conditions or future projections is professionally deficient. This method fails to account for market shifts, interest rate changes, or evolving economic sentiment, potentially leading to an unrealistic valuation. It risks violating the duty of care owed to the client by providing outdated or incomplete advice. An approach that prioritizes recent short-term market fluctuations, e.g., the last 12 months, without a broader historical context or consideration of underlying economic drivers is also problematic. While recent trends are important, they can be anomalous and do not necessarily represent sustainable future growth. This can lead to over-optimistic or overly pessimistic valuations, failing to provide a balanced perspective as required by ethical standards. An approach that focuses exclusively on national economic indicators, without tailoring them to the specific Victoria and Melbourne market conditions, is inadequate. While national trends provide context, local factors such as state-specific employment, infrastructure projects, and regional housing supply significantly influence property values in Victoria. Ignoring these specific nuances can result in a valuation that is not representative of the actual market. Professional reasoning. Professionals should adopt a systematic and data-driven approach to market analysis. This involves 1. Identifying all relevant economic and market factors impacting the specific jurisdiction, Victoria. 2. Gathering reliable historical and current data for each factor. 3. Applying appropriate analytical techniques, including statistical methods and scenario planning, to forecast future trends. 4. critically evaluating the assumptions underpinning the analysis and their potential impact on the outcome. 5. Communicating the findings clearly and transparently to the client, including any uncertainties or risks associated with the projections. This process ensures that advice is not only accurate, but also ethically sound and compliant with regulatory expectations.